Be ready, 5 seconds. The relevant facts in short is that plaintiff respondent had filed the suit for declaration of title, denying any right, title, and interest of defendant appellant over the suit property. The defendant appellant, by filing written statement, contested the suit on various grounds, including non-joinder of necessary parties, and after due consideration of oral and documentary evidence adduced by the parties, apart from others, finding the suit bad for non-joinder of necessary parties, issue number 3 dismissed the suit, of course without cost. The plaintiff respondent preferred appeal against judgment of the trial court and the lower appellate court after full-fledged hearing concluded that suit suffers with defect for not impleading necessary parties the vendors of the plaintiff, and if any final adjudication is done, would be of no avail and may create several complications, remitted the suit to the original court with a direction to implead such necessary parties, and after fresh hearing re-decide the matter, giving rise to present appeal. It is contended by learned counsel for the appellant here that lower appellate court has, instead of affirming decree of the trial court without any reasonable cause contrary to law, remanded the appeal, causing undue harassment to the parties concerned. On the other hand, contention of learned counsel for the plaintiff respondent is that lower appellate court has exercised its jurisdiction as contemplated under Rule 23 and 25 of the Code of Civil Procedure. There appears no reason for any interference. The lower appellate court in the appeal, after full-fledged hearing in appeal, also appears arriving at conclusion that suit is bad for non-joinder of necessary parties. In the event such order is permitted to continue, it tantamounts to give undue favor to the plaintiff respondent to fill up the laches committed by him, since beginning in spite of repeatedly being brought into notice. The law does not permit to do so. Consequently, impugned order is not sustainable. Accordingly, it is set aside. The appeal is hereby allowed with a direction to the lower appellate court to decide the appeal afresh on all issues, and further directed to dispose of the appeal within 3 months on receipt of the record. Learned counsel for the parties are directed to appear before the lower appellate court or its successor in office on 9th March 2015. Meanwhile, registry of the court is directed to ensure receipt of copy of this judgment.